Good afternoon from sunny Las Vegas. I'm without my assistant today, so I'm winging it. We're going to have a couple of topics today, but we're going to start with a review of The Real Lincoln by Charles L.C. Minor. Small book, 222 pages, entirely based on testimony of his contemporaries, historians from the era, and revealing the real Lincoln. The author of this important volume offers a concise yet compelling expose of the 16th President of the United States, Abraham Lincoln. This book is documented extensively and it's exclusively from northern sources, many of which include Lincoln's former friends and associates. As Minor points out, quote, "Few who read this book will escape the conclusion that the real Lincoln was a very different man in his private and his public life from what the world's verdict pronounced him to be." Another related book is The Genesis of Lincoln by James Harrison Catney in 1899. Minor's book was published in 1904. He began his study in the 19th century because of some of the conflicts of the history he was reading by those who were there at the time and what the Lincoln cultists were attributing to Lincoln. So let's have a look at some of the interesting things which I find most revealing. And one of the questions that I still have is how Lincoln ever became president to begin with. It's true that he was a rich railroad lawyer and that the railroad moguls had a good reason to want Lincoln to be president because he was already invested in the completion of the Transcontinental Railroad, because they had the plan to have the terminus for the completion of the Intercontinental Railroad, the Pacific Railroad, in Council Bluffs, Iowa, where Lincoln, prior to his becoming president, had purchased land. Now, Springfield, Illinois, was at the time one of the fastest growing communities in the country, as was Chicago. Lincoln lived there. He had his offices there. And yet he bought land in a undeveloped area, very little development in Council Bluffs, Iowa. The development of that area came somewhat after the completion of the Pacific Coast Railroad. At the time, the port on the Missouri River was its most used commercial input. So what we do today is we discover, do I have anybody live out there? I don't see anybody. We'll attempt to begin to discover Lincoln and his war, because in all in almost all respects, it was Lincoln's war. I'm going to jump back to the policies of the Lincoln administration. But I think it's important, since I don't seem to have anybody in the chat room. We'll see here. To give a connection to a link to a very good site for constitutional conceptions. If I can get this to work. Well, I'm not getting it to work, so we'll skip that. Have to put it up later. But anyway, Constitutional Conception Foundation has reviewed the missing 13th Amendment. The Constitution for the United States of America, but it had become the Constitution of the United States of America. And they passed Congress, the 13th Amendment, the original 13th Amendment, passed by Congress in May 1st, 1810, and was ratified by the majority of the states, which is all it needed. It had 13 of the 16 states existed at the time, 18 to come, by December 9th, 1812, during the war. No doubt the war was some distraction. It states, if any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, or shall without consent of Congress accept and retain any present, pension, office, or emolument of any kind whatsoever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States, and shall be incapable of holding any office of trust or profit under them or either of them. Means you couldn't get a job as a dog catcher. Considerable controversy surrounds this amendment. The official position of the federal government is that it was never ratified. But in the past few months, past year, there is more than ample evidence that shows that the amendment was properly ratified on December 9th, 1812, and if not then, certainly no later than March 10th of 1918, or 1819, excuse me, 1812, and if not, certainly by then, by March 10th of 1819. There's been a lot of discussion over the years about the fact that the amendment was established to prevent or prohibit members of the Bar Association from participating in government offices. If that were the sole purpose of the amendment, it is wasted energy. Our founding fathers had a much more straightforward than that. Article 1, Section 6, Paragraph 2 of the Constitution for the United States of America states, no senator or representative shall, during the time for which he is elected, be appointed to any civil office under the authority of the United States which shall have been created or the emoluments whereof shall have been increased during such time, and no person holding office under the United States shall be a member of either house during the continuance in office. That's Article 1, Section 6, Paragraph 2 of the Constitution of the United States. This paragraph, or this provision, was established to maintain the clear dividing line drawn between the three branches of government. Violation of this provision creates a direct conflict of interest because members of the bar would be officers of the court and in the judiciary branch and members of the legislature and legislative branch, which can't be allowed. For over 50 years, the 13th Amendment was included in publications of the Constitution in the United States. That takes it up to directly 1860, 1861. Many states, territories, and even the federal government itself printed copies of the Constitution containing this amendment. It was unlawfully removed by persons unknown for their own personal greed and aggrandizement, even though it was properly ratified. It appears that it was never enforced. Thus, all the laws, treaties, and appointments of officers to government positions and other acts and actions of the federal government since 1812 are of questionable validity and may therefore be null and void. You can examine for yourself the images of the various documents and prove conclusively the validity of the 13th Amendment by going to Constitutional Concepts Foundation. And you can search elsewhere. There's plenty of evidence. It's very interesting to note that the 13th, 14th, 15th, and 16th Articles Amendment had numbers assigned to them at the time of ratification. Now, what that means is that most amendments didn't get a number until after they were ratified. So during the ratification process, they weren't numbered. The reason behind this numbering was to ensure that the removal of the valid existing 13th Amendment was fully hidden by the proposed and wrongfully numbered new 13th Amendment. To have just numbered the new proposed amendment as 13 and then not numbered the others would have called attention to the facts surrounding the situation. Whoever was behind the removal of the valid 13th Amendment had to number the next few amendments so as to further hide their unlawful actions. This amendment was for the specific purpose of banning participation in the government operations by attorneys and bankers who claimed title of nobility of Esquire. These people had joined the International Bar Association or the International Bankers Association and owed their allegiance to the King of England. Banning titles of nobility began in the Articles of Confederation and continued 2 places in the Constitution, and finally was added as an amendment to the Constitution, an amendment that was needed as other bans had no teeth in them to punish those persons who chose to ignore constitutional law. We see it happening today. And they list the ratification of the states and when, and the 3 that didn't. This takes us to the 14th Amendment. Another piece of exercised unlawfulness. It does well here to remember that there were no existing states in the South at the time. So how did the states ratify the 13th or 14th Amendment? Because they were military districts for years, not states. They were military districts of the Union. It is difficult to emphasize strongly enough the importance of the memorandum written by Judge Lander, H. Perez, or of the 1957 Georgia Memorial, or the decision by the Utah Supreme Court, or the statement by Congressman John R. Patrick of Louisiana on the floor of the House, all concerning the validity of the so-called 14th Amendment. The question, can validity be erased? does the 1957 Georgia Memorial that was passed by the Georgia legislature and signed into law by the governor, along with the 1968 decision by the Utah Supreme Court, and the memorandum prepared by Judge Perez of Louisiana, effectively kill the 14th Amendment pursuant to the full faith and credit provisions of the Constitution for the United States of America. Full faith and credit shall be given in each state to public acts record and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which the acts, records, and proceedings shall be provided, and the effect thereof. Each state is to be recognized as the public acts and judicial proceedings of every other state. This is designed to eliminate the potential for confusion over a number of situations. Article 4, Section 1, Constitution for the United States of America. If not, why not? Remember, we have a valid law passed by the Georgia legislature and served on the federal government 50 years ago, and we have judicial rulings from two different states, Utah and Louisiana. And in 1975, the Utah Supreme Court made the following statement in a court declaration: I cannot believe that any court in full possession of its faculties could honestly hold the amendment was properly approved and adopted. State v. Phillips, Pacific Reporter, 2nd Series, Volume 540, page 941, 942, 1975. Number 2, actions were taken and the documentary evidence recorded in public records for all to see many years ago. The only logical explanation as to the failure to respond is that there is no valid response because the allegations are true and correct. Consider the words of Benjamin Franklin. Sir, there are two provisions which have powerful influence in the affairs of men. There are ambition, avarice, love of power, and love of money. Separately, each of these has a great force in prompting men to action, but when united in view of the same subject, they have in many minds the most violent effects. Place before the eyes of such men a post of honor that shall be at the same time a place of profit, and they will move heaven and earth to obtain it. A vast number of such places it is that renders the British government so tempestuous. The struggles for them are the true source of all these factions, which are perpetually dividing the nation, distracting the councils, and hurrying sometimes into fruitless and mischievous wars, and often compelling submission to dishonorable terms of peace. Benjamin Franklin. As we examine the lies that surround and conceal the real facts about the bloody war in which hundreds of thousands of Americans were slaughtered, brother killing brother, Christians killing Christians, whole southern states and millions of lives were destroyed, and out of the chaos, the blood, the mud, the fire, and the ashes, utter destruction, came the 14th Amendment, which effectively dismantles the Constitution. Now, I've had personal experience with the 14th Amendment. I used the 14th Amendment as a citizen's advocate for litigation, for appearances in court, many times over in several states. Realizing all the time that the 14th Amendment had effectively dismantled the Constitution. But when you're in an adversarial court, which is no longer or has never been a common law court, and under admiralty law, you have to play the game by their rules. So I used the 14th Amendment. At one point in my experience, I, along with a bunch of citizens advocates and a handful of lawyers, I proposed that we file a lawsuit or a suit, class action, or that we file a suit against the 14th Amendment. Basically, it was to challenge the 14th Amendment and the validity of the 14th Amendment, because it sets up a caste system in this country, or set up a caste system in this country, and everything you enter into courts in class action is the 14th Amendment is your means of getting into the court, which means that every time that you file a class action, you're setting up a caste or a group within the structure of your government, or a group of citizens. That's another issue, which is totally against the precepts and the principles of the Constitution, because that's what we were trying to get away from Britain for. Our forefathers fought valiantly to try to break the chain of the caste system. The 14th Amendment, as we examine the documents and true facts of history, we will learn that the 14th Amendment was fraudulently and unlawfully and illegally proposed by the U.S. Congress, rendering it null and void at the onset. Ratified in southern states by rump legislatures, literally by military forces at bayonet point, by threat and duress and coercion, rendering it null and void in the second instance, had nothing to do with giving freed slaves citizenship status. It instead created a status of citizenship for all Americans, U.S. citizens rather than citizens of their respective states, which in effect enslaved us all. Dissolved and replaced the constitutional law with military law and the laws of commerce and admiralty. Now we're going to have a long discussion about this, because one of the greatest battles I've had before city councils, state legislatures, is that we've evolved our law enforcement into nationalized, militarized authority over citizens rather than peacemakers. One of the few bastions of peacemakers lies in our sheriff's departments. In a very real sense, dissolved and replaced the constitutional law with military law and laws of commerce and admiralty, and in a very real sense became a new constitution within the Constitution. I'm going to take this up one step at a time, but what I would like to see you do is go to the Constitutional Concepts Foundation, study the site, do the research, find out for yourself. On Bankster Fables, I'll list the link to the site. And if you are moved to find out the truth, you might purchase the book by Charles L.C. Minor, published in 1904, $14 online. Maybe a little more than that on Amazon because it's hardback. It's a small book, 222 pages. has an appendix of 51 pages of documented evidence by historians of the time. All of this, everything that Minor has in this book is from testimony of Lincoln's contemporaries. And Lincoln effectively destroyed what hope we had for a free republic. We'll get into some earlier questions, and we'll study Lincoln at the next broadcast. I don't seem to have anybody in the chat room, so if there's interest, perhaps next week we'll get into this deeper, since I don't have my assistant isn't available, and we don't have an audience at the moment. So I'm going to close this session and hope that we generate a little more interest next week so that you can ask questions, and we will see if we can answer them, and if we can't, we'll do the research to find the answers. But I need to know what your questions are in order for us to all learn the truth. Thank you, and good afternoon.